The American legal system, much like a low-budget airline, is full of surprises. The creator of this video, J. Bogan Bay, focuses on one such aspect of the 13th Amendment in criminal law, which is the concept of the right of publicity, a property right that allows individuals to control the commercial use of their name, signature, likeness, and identity. Upon a lawful conviction, servitudes may be imposed. J. Bogan Bay claims that a conviction on a non-existent criminal offense violates the 13th Amendment. This right is distinct from servitudes and easements, which are both non-possessory rights in another person's land. This right is recognized as belonging to the people via the 10th Amendment. Servitudes and easements differ in the type of right and the purpose of the right. A servitude is a broader term that includes both easements and covenants. Easements specifically grant the holder a right to use another person's land for a specific purpose. For example, an easement might allow someone to cross a neighbor's property to access a road. Servitudes, on the other hand, can include restrictions on how land can be used, such as a covenant not to build a fence. Fasten your seatbelts, folks, because understanding these property rights can get quite intricate. And remember, when the government engages in commercial transactions, it is subject to the same liability as private persons, as established by the Alfred Dunhill and Clearfield Trust doctrines. J. Bogan Bay retained his right of publicity, a right recognized in the Bill of Rights. The 10th Amendment to the United States Constitution, ratified in 1791, expresses the principle of federalism. It states that any powers not given to the federal government are reserved for the states or the people. This means that any powers not delegated to the federal government are reserved for state and local governments or to the people. J. Bogan Bay, being one of the people, retained his own publicly rights. Imagine you have a neighbor, let's call him Kevin. Kevin is a friendly guy who loves gardening and often shares his homegrown vegetables with you. Kevin wants to access the public road, but his driveway is blocked by your prize-winning petunias. These flowers have grown so beautifully that they now spill over into Kevin's driveway, making it impossible for him to drive his car out. An easement could be the solution. This is a common legal arrangement that can help resolve such issues between neighbors amicably. An easement is a legal right that allows someone to use another person's property for a specific purpose. It's like a mutual agreement that benefits both parties. Similarly, the government may exploit a convict's right of publicity on a lawful conviction. In this case, Kevin could have an easement to drive across a portion of your property. This would allow him to access the road without disturbing your beautiful garden. There are two main types of easements: easements appurtenant and easements in gross. Understanding these can help you decide which one suits your situation best. An easement appurtenant benefits a specific piece of land. Think Kevin's driveway. It benefits his property directly, ensuring he can always access the road. An easement in gross, however, benefits a specific individual or entity, not a piece of land. This type of easement is more personal and less tied to the property itself. These are less common and often involve things like utility lines. For example, a utility company might have an easement in gross to run power lines across your property. In the case of Mr. Bogan Bay, he retained and transferred his right of publicity to the Seven Seeds Family Trust. This means his claim is substantial if the state fails to justify merging with financial institutions to enforce a civil claim against him based on a consumer credit agreement. Now let's talk about involuntary servitude. This isn't just being forced to watch your least favorite reality TV show, it's far more serious. Involuntary servitude is a fancy legal term for forced labor. It's a violation of the 13th Amendment to the U.S. Constitution, which abolished slavery and involuntary servitude. You might be thinking, wait, isn't involuntary servitude a thing of the past? Sadly, no. It still rears its ugly head in various forms like human trafficking and debt bondage. But how does this relate to J. Bogan Bay and his unusual legal argument? Well, that's where things get interesting. Title 42, USC 1994, is a bulwark against peonage. Title 42 deals with health and human services. Enter 42 USC Section 1994, a federal statute that throws a legal wrench into any attempts to revive the horrors of peonage. This law was enacted to ensure that no one could be forced into labor against their will to pay off a debt, a practice that was all too common in the past. Peonage is essentially a system where someone is forced to work to pay off a debt. It was a brutal and exploitative practice that trapped people in a cycle of poverty and servitude, often with no end in sight. It's like indentured servitude's evil twin. While indentured servitude had a set term and some legal protections, peonage was indefinite and far more abusive. Section 1994 says, "Nope, not having that," and declares any legal process that enforces peonage to be null and void. This means that any court order, contract, or agreement that tries to impose peonage is automatically invalid. Now you might be wondering what this has to do with easements or J. Bogan Bay. It's a fair question and the connection might not be immediately obvious. Well, Bogan Bay argues that the judgments against him, stemming from a consumer credit agreement and non-existent criminal offense, are a form of peonage when his right of publicity was forcefully pledged to financial institutions' benefit. He believes that the financial obligations imposed on him are akin to being forced into labor to pay off a debt, which debt rightfully belongs to the financial institutions. He claims he's trapped in a system of forced financial servitude. This is a serious allegation, as it suggests that the legal system is perpetuating a form of modern-day peonage. And this is where he makes the unorthodox but valid connection to easements in gross. By linking his to servitudes recognized in property law, Bogan Bay realized that slaves were considered property and that the legal framework being enforced upon him is unjustly keeping him in financial bondage. Section 5. The Claims of J. Bogan Bay. This section delves into the complex and troubling case of J. Bogan Bay, a man who has been entangled in a web of financial and legal exploitation, premised on a non-existent criminal offense. Bogan Bay alleges that state officials and private financial institutions have merged, and by this merger have been illegally profiting from his inmate trust account, siphoning off funds that should rightfully be his. This is recognized as an easement in gross, as it benefits private parties and not the land. The Constitution prohibits this type of servitude and only allows servitudes that benefits the land. This means the state's police power must be properly accountable. Essentially treating it as their own personal piggy bank, these entities have been exploiting his financial resources for their gain. He claims this financial exploitation is akin to an easement in gross, a legal term that refers to a right to use someone else's property for a specific purpose. These entities, according to Bogan Bay, are benefiting from his situation without any real connection to any specific property, making the exploitation even more egregious. It's important to note that Bogan Bay is representing himself in this legal battle, a daunting task for anyone, let alone someone without formal legal training. He's navigating the complex world of legal arguments and precedents without the assistance of a lawyer, relying solely on his determination and resourcefulness. This makes his case all the more remarkable, showcasing his resilience and tenacity in the face of overwhelming odds, but it also highlights the challenges faced by many individuals who find themselves up against the legal system, often without the resources or support they need to fight back effectively. Furthermore, Bogan Bay argues that the state has no police power to hear the criminal offense claim against him. The legislature repealed and reorganized the criminal statute used against him ex post facto, revealing that the criminal offense is non-existent. The cases mentioned can provide insights into the legal framework surrounding interest earned on inmate accounts in the following ways. Hudson v. Palmer, 1984. While this case addresses property rights, it implies that state officials must manage inmate property, including funds, lawfully. If state officials are benefiting financially from inmate accounts without proper authorization or oversight, it could lead to legal challenges. Sandin v. Connor, 1995. This case established that inmates have certain rights, but it also set boundaries on those rights. If the management of interest from inmate accounts imposes atypical hardships, it may be challenged as a violation of rights. Lewis v. Casey, 1996. This case underscores the right of inmates to access the courts to challenge unlawful practices. If inmates are not receiving interest earned on their accounts, or if such interest is being siphoned off, they may have grounds to file suit. Holt v. Hobbs, 2015. Although primarily about religious rights, this case reinforces the principle that inmates are entitled to fair treatment. This could extend to how their financial accounts, including interest, are managed. Rashad v. Johnson, 2010. This case emphasizes the need for transparency and accountability in the management of inmate funds. If interest accrued on inmate accounts is not properly accounted for or distributed, it could violate principles established in this case. Woods v. Edwards, 2002. This case highlights the importance of fair handling of inmate funds. If state officials are profiting from inmate accounts or not crediting interest appropriately, it may constitute a breach of duty. In summary, these cases collectively suggest that inmates have a right to fair and transparent management of their accounts, including any interest earned. If state officials or private institutions are unlawfully profiting from these accounts, inmates may have legal grounds to challenge such practices based on the principles established in these rulings. Section 6. Unjust enrichment, a question of fairness. Adding another layer to his argument, J. Bogan Bey throws in a claim of unjust enrichment. This legal concept essentially says that it's unfair for someone to profit at another's expense without a justifiable reason. It's like finding a $20 bill on the ground and then refusing to share it with the friend who dropped it. J. Bogan Bey argues that the state and financial institutions are unjustly enriching themselves by allegedly exploiting his inmate trust account. He claims they are benefiting from his situation without any legal basis or justification. Section 7. State liability in contractual obligations. Engaging in commercial transactions may expose the state to legal claims. Let's consider a few cases. Kelly v. State, 739 NE, 2 230, IND 2000, examines state liability in tort actions. This case reinforces the notion that when the state engages in activities akin to private enterprises, it may be subject to the same legal responsibilities. Vanderburgh County v. State, 755 NE 2 612, IND 2001, discusses the state's liability in the context of commercial transactions. It explores how the doctrine of sovereign immunity applies when the state acts in a proprietary capacity. City of Indianapolis v. Edens, 754 NE 2 596, IND 2001, explores the liability of municipalities. It examines the circumstances under which they may be held accountable for actions taken in a commercial context.